All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good afternoon. Counsel for the defense of Mr. Ngai. Their presence have been significantly amended. Please, Mr. Knopf, tell us how it looks like now. Microphone, please.
Good afternoon, Mr. President Jonas. Good morning. Good afternoon, Mr. President. The first row, Barbara Smatsula, she was not here this morning. She will guide us through the PowerPoint presentation today. Ms. Sarah Pedroso, she will also take part in the submissions in the middle part. On the first row on the left side, co-counsel Ms. Marilyn Proux, the Swina Eleftherio, my own director, Mrs. Knopf-Hamburger. Then we go to the second row, Melissa Beaulieu, Michael Rouse, Matthias Goffet, and Lou Quignon, Chiara Giudici, and Alexander Desdavi. I think that's complete.
Yeah, I think so too. Thank you, Mr. Knopf. And I can already give you the floor for your submissions.
Yes.
And I think we should handle it like we did in the morning, meaning that after 1.5 hours, for the reasons already explained, we have a short break. Or whenever you think, when it comes close to 1.5 hours or a bit over this time, when you think it's appropriate for you and best for you, you let us know.
Thank you, Mr. President. Jonas. We can first pull up Ms. Matsula, the outline already in the PowerPoint. Yes. Mr. President, good afternoon, everyone. You see here our outline. I will do the introduction. The second part, Ms. Pedroso, 3, 4, 5, and then I'll return to the court with topic 6 and 7, the conclusion. And we are mindful of the time of 2 hours, Mr. President. Jonas, listening to the OTP submissions yesterday, it was clear that their submissions were merely a last attempt, a last desperate attempt to relitigate the evidence under the guise of refuting Mr. Cassona's alleged marginal participation and intent, if proven at all. Their submissions, in our view, reveal again the weakness of their case. And they should, in terms of sentencing, totally be disregarded, since the prosecution yesterday simply was trying to get a second bite of the apple, while again ignoring the abundance of exculpatory evidence in this case, as argued in our closing brief and closing arguments. What was also striking, Mr. President Jonas, yesterday, how the prosecution's office totally misrepresented the confirmation decision in this case, and even asked your court to circumvent this confirmation decision, the leading document at this moment. In yesterday's transcript, page 23, lines 12 till 28, the English version, it argued that the confirmation decision does not exclude Mr. Cassona's participation in a common plan. Jonas, the prosecution tries to increase the so-called level of participation, if proven at all, and intent under 25(3)(c) and D of the statute by using the pre-trial chamber's decision where it not applied the common plan as a framework through which potential criminal liability is to be established. That is what happened before the court. And as we all know, the pre-trial chamber did not make findings under the framework of a common plan at all. However, the prosecution now tries to import such a common plan to the degree of participation and intent under the Articles 25(c) and C and D. But this is not what the pre-trial chamber intended with its decision. Mr. President, the pre-trial chamber specifically found that Mr. Cassona's contribution was not that of a principal, and thus it could not be qualified as essential. Prosecution is now ignoring this, which is akin to what they tried to do in the Bemba et al. Case. As you honors know, in that case, the prosecution alleged Mr. Babala's responsibility was demonstrated by his participation in the common plan. That was the argument of the prosecution in that case. But the chamber rejected this formulation and found that the prosecution was merely attempting to prosecute Mr. Babala as a co-perpetrator, despite the confirmation decision in the Bemba case rejecting that mode of liability. The chamber further found that following the prosecution's arguments would amount to effectively an amendment of the confirmation decision. And I referred the court to the paragraphs 874 till 876 of the Bemba et al. Trial judgment. Your Honors, this is not the only example of how the prosecution tries to circumvent the confirmation decision in this case. Both the prosecution and the LRV try to characterize Mr. Cassona's contributions, if proven, and even ask the court to add charges that not have been confirmed, Mr. President. Similar to its submissions regarding Mr. Cassona's participation in the common plan, the prosecution in its written submissions qualifies his alleged contributions as being pervasive. They even dare to state that these contributions impacted upon every aspect of the commission of the charged crimes. This is to be found in paragraph 2021 of their written submissions. Mr. President, this language, pervasive, by the prosecution also amounts to a circumvention of the clear language and findings of the confirmation decision. Now, let us speak about the LRV. They go even further than the prosecution. Mind you, they expressly try to amend the charges when they say that without Mr. Cassona's, they call it essential contribution, the crimes could not have been committed in the same way. Paragraph 2, 24, 46 of the victim's submissions. In the same vein, they state that Mr. Cassona was one of the so-called masterminds of the plan of Mr. Bozizé to reclaim power. This is to be found in paragraph 44 of their submissions. Your Honors, we all full well know in this court that Regulation 5.5 was not applied in this case. That is the judicial reality. Therefore, qualifying Mr. Cassona's contributions as essential is plain wrong. Both the prosecution and the LRV even add an additional incident of rape to the charges. And we all know that the chamber has rejected this, the confirmation of charges chamber. This will be found in our closing arguments and also transcript 309, English version page 76, lines 1 till 6. Therefore, adding this incident of rape is in contravention with not only the confirmation decision as such, but also the explicit pre-trial chamber decision on the prosecution's request to amend the charges pursuant to 61.9 of the statute. You can find the pre-trial chamber's reasoning in the last decision in paragraphs 23 and 24. Your Honors, in trying to substantiate a 20-year sentence, mind you, the prosecution compares this case to the Charles Taylor case. Mr. President, I was self-counsel in one of the cases related to Charles Taylor at the Special Court for Sierra Leone, and also apart from that knowledge, we can say with full conviction that the Charles Taylor case bears no resemblance to that of Mr. Cassona. Taylor was given a 50-year sentence after following 5 aggravating factors, Mr. President. 5. First, Chamber found in that case that the actions of Mr. Taylor, then President of Liberia, caused and prolonged the harm and suffering inflicted upon the people of Sierra Leone as a neighboring country. not his own country. That extraterritoriality was seen as an aggravating factor by the court as such. And secondly, his special status as head of state was also be seen as an aggravating factor. And third, Taylor abused his authority as held by the court as the president of Liberia, since he was in a unique position to use his access to the state machinery and public authority to aid and abet the RUF and the AFRC. Fourth, Taylor abused his position of public trust, aggravating factor. And as the head of state and member of ECOWAS, as the court held, he was part, or ECOWAS committees, he was part of those peace processes, but his actions undermined that process. We come back to this point later in time. Fifth, Taylor benefited personally from the crimes through financial gain in his steady supply of diamonds. And the Chamber made these findings in paragraphs 97 and 103 of the Taylor sentencing decision of 30 May 2012. Now, Mr. President and Your Honors, there is not a single of these aggravating factors, not a single one, that is present or bears the slightest resemblance with Mr. Ssona. The prosecution does not argue them. They just throw over to you the decision of Taylor. Therefore, a comparison between Taylor and Mr. Ssona cannot be made. Indeed, the Chamber in the Taylor case highlighted, above all, the uniqueness of that case when it acknowledged its breaking with the principle that lesser sentences are warranted for accessorial modes of liability. It was an exception. The Taylor case was an exception to this principle rule in international law. But it's because it found in paragraph 100 of its sentencing judgment in Taylor that the special status of Mr. Taylor as a head of state puts him in a different category of offenders for the purpose of sentencing. That was the ruling of the court. Therefore, no comparison is warranted in this situation. Before I address the topics further in the outline, it would be remiss if we don't say something about the procedural posture in this case. Mr. President, we are presenting our submissions to the Chamber on sentencing before there has been a verdict, as we all know. This procedure, therefore, constitutes a significant departure from the court's jurisprudence. And therefore, we need to publicly restate our position in this case, which is that Mr. Ssona is not guilty of any of the crimes charged. He proclaims his innocence, as also in detail explained to the court in his unsworn statement. And based on the evidence presented in this trial, we strongly believe as counsel, as lawyers, that the only reasonable conclusion can only be that he is found not guilty of these crimes. So it would come not as a surprise for anyone in this court that you will not hear Mr. Ssona or his defense team today saying that he expressed remorse. My learned colleagues across the aisle insist on this. Why does Mr. Yekatom and Mr. Ssona doesn't show remorse? Such an act would imply that Mr. Ssona believes he's guilty. He's not. It is his right to claim his innocence, and the prosecution and LRV submissions about the lack of expression of remorse should be disregarded. And Mr. President, Your Honors, contrary to the LRV and the OTP views on this issue expressed yesterday, and as the court knows, even expressed by some state parties during the ASP on the 3rd December 2019, I will not mention the countries, but the court knows on the record what countries we refer to. A failure, the acquittal is not a failure. It's been perceived as a failure of the system. After the acquittal of Mr. Gbagbo and Laurent Gbagbo and Mr. Charles Blé Goudé, it was circulated that this was an example of a failure of the system of international justice. I would put to the court the contrary. An acquittal is not a failure of system, it's rather a victory of the justice system. It's part of the justice system. And in this case, it should be seen as justice for ssona and also the car, considering the absence of evidence. Mr. President, if you look at our outline, I will now arrive at topic 2, the issue of participation intent. We first address the minimal participation intent of Mr. Ssona if he would be convicted against all odds by the chamber. It is astonishing, Mr. President, Your Honor, that the prosecution and the victims can request that Mr. Ssona potentially serve effectively the rest of his life, considering his age and the average age of living in the car, the rest of his life behind bars, when they are completely incapable of showing how he, Mr. Ssona, contributed in concreto to the crimes, which they have not shown before this court. Again, such an approach goes against the principles of sentencing. Under the gravity assessment, the prosecution and victims' representatives must specifically show how somebody like Mr. Ssona contributed to each of the 31 counts. This demonstration is completely missing, Your Honors, in this case. You've not heard it. Instead, they put up smoke screens. Smoke screens clearly meant to distract Your Honors from the fatal flaw in their sentencing submissions, which are merely based on a repetition of the absence of evidence during their submission in December. The first smoke screen, let us look at the first smoke screen. They misstated charges by amending the confirmation decision. As an example, let us look at paragraph 20 of the prosecution submissions. Prosecution claims that Ssona's alleged responsibility for the enclave at l'École de la Liberté would be linked to his role as anti-Balaka coordinator. Your Honors, the pre-trial chamber here specifically found that he, Ssona, did not exercise control over the crimes. That's paragraph 103 of the confirmation decision. His responsibility for the enclave was based on it being part of the same course of action as to the 5 December Bangui attack. That's something quite different. It's to be found paragraph 112 of the confirmation decision. Therefore, Your Honors, Mr. President, these submissions on authority control over those anti-Balaka allegedly responsible for the École de la Liberté enclave are inapposite. Their submissions also completely contradict the evidence, their own evidence. We have made extensive submissions on the lack of control over the com zones. We simply refer to our closing brief, paragraph 559 till 565, as well as the closing arguments, transcript 309, English version, page 77 till 81. We would like to remind the chamber of your own witness, Mr. President, the court witness, Ms. Samba Panza. Her testimony on this very point. What did she say? We all full well know that she said that while the movement may have started with a noble vision, it had been infiltrated by rogue elements, and she qualified those as bandits. She specifically testified that the coordination did not have any control over these young people in the neighborhoods and in the field. You can find this reference in transcript 249, English version, page 47, lines 24 till 48, line 5. And you see it here on the slide. A clear testimony of your own witness, the chamber's witness. Never, whether prior to 5 December or after, did Mr. Ssona have any real authority in concreto or control over the anti-Balaka, as confirmed by the chamber's own witness, Ms. Catherine Samba Panza. Your Honor, that's to be found at transcript 250, English version, page 13, line 1 till 10. Because of this lack of control and authority, the principle of gradation does not apply to this case, as we explained in our brief written submissions, paragraph 14 till 16. The second smoke screen to distract the court from the core issue of sentencing is the overly broad claim regarding the contributions of Mr. Ssona. Why are these claims so overly broad? Because they do not show, Mr. President, Your Honors, they do not show how these contributions affected, in essence, the commission of the crimes during the 5 December attacks and their aftermath. Your Honors, the prosecution stated yesterday at page 28 of the English version, line 11, that the defendant's assistant in the crime may not have an effect on the execution. And as such, it would suffice that the contribution affected any phase of its commission. That may be true, Mr. President. That may be true legally, but that does not dispense the prosecution of its burden of practically showing how that was the case in a specific situation. What phase of commission of crimes was affected by Mr. Ssona's contribution? What phase? We still have to wait for the answer. The answer never came. The prosecution never gave the court a clear answer because there's none. There's no evidence. Prosecution has made no demonstration of how any of the purported contributions affected the commission of crimes charged. As the court have read in our closing brief and heard in our closing arguments, all of these purported contributions made by Mr. Ssona are unsupported by probative evidence and have absolutely no causal link to the crimes charged as required by 25(3) and D. Both the prosecution and LRV merely generally state that Mr. Ssona has contributed to the crimes by taking steps to finance, structure, instruct and liaise with the anti-Balaka, and that's to be found in paragraph 21. Where was the physical evidence that Mr. Ssona was at the border in Cameroon? There's no single witness came before this court to testify that he or she saw Mr. Ssona personally at the border. These preliminary findings regarding the role of Mr. Ssona in the confirmation decisions, where the prosecution is referring to, are not sufficient for sentencing. After 5 years of trial, it was incumbent on the prosecution to concretely show this court how each of those alleged contributions impacted on the 5 December attacks and their aftermath. Such a showing was specifically important and essential in the context of accessorial liability, where Mr. Ssona's responsibility does not stem from participation in a common plan, as we saw from the confirmation decision. And what does the prosecution say about accessorial liability in this case? It simply says, well, it does not diminish Mr. Ssona's culpability. Full stop. And here, I refer you, Honours, to paragraph 4 of the written submission of the OTP. And what do they say in support of this? They support this with a separate opinion in the Lubanka case, which is completely unrelated to sentencing, and the appeals chamber in the Charles Taylor case. Again, this comparison with the Taylor case is an opposite. The appeals chamber in Taylor in 2013 found that the trial chamber illustrated how precisely Taylor's actions and conduct influenced the actual commission of the crimes charged. The financial, logistical, military support to the RUF and the RFC in Sierra Leone. For example, the chamber found specifically in that case that the arms, ammunition and military personnel provided by Charles Taylor were used during the RUF, RFC operations, offensives, in which the crimes charge occurred. They also found, that chamber, that the communications supported by Taylor were actually used in the offensives during the crimes charged. That's to be found in footnote 1531 of the Taylor's appeals judgment of 2013, Your Honours. This view is also endorsed in paragraph 6914 of the trial chamber's sentencing decision in Taylor of 2012, I already referred to it, in which that chamber made explicit findings on the causal link between Taylor's contributions and the crimes. The causal link, they even used the word indispensable for RUF military offensives. That was the qualification of the chamber. And that is the precedent the prosecution is relying on, Mr. President. It's a precedent which is totally excluding the role of Ssona in this situation. We all know Mr. Ssona the prosecution never in that case showed how the alleged ammunition, personal logistical support, even the so-called besoin emails, forgetting the direct evidence of the witnesses who came before this court who refuted that emails, how all that information played a role on the 5 December attacks in the aftermath. Where is the concrete link they were able to show? There is no link shown. By citing Taylor as an outlier case from a different tribunal, the prosecution conveniently ignores prior precedent at this court. The LRV, by the way, correctly referred to the appeals chamber decision Lubanga of the ICC of the 1st December 2014, paragraph 462, where it held that, generally speaking and all other things being equal, a person who is found to commit a crime, him or herself, bears more blameworthiness than a person who contributes to the crime of another person or persons. Of course, we'll full well know that a chamber cannot automatically give a reduced sentence in case of accessorial liability. This requires a case-by-case analysis. That's true. But that case-by-case analysis requires that the prosecution and victims' representations can show, which it cannot in this case, how the actions of a defendant, like Mr. ssona, affected, in this situation, the 5 December attacks and the aftermath. If that's not the case, like here, how can the chamber make an assessment on the culpability of somebody like Mr. ssona? It's impossible, Mr. President. That's why we argue at closing that the prosecution has failed to meet its burden of proof. And Mr. ssona should also, for that reason, be acquitted of all counts. An overly broad claim of the prosecution is that Mr. ssona contributed to the organizational policy to target Muslims. They further state that his alleged contributions go beyond the crimes charged. Mr. President, the supposed evidence for this sweeping claim is found in footnote 13, which we show here, of the prosecution submission. Let us have a look at it. Footnote 13, if the court can see here, consists of 5 speeches, 2 of which were not even made by Mr. ssona himself. There is no evidence that they were made on his behalf. The 2 speeches are to be found in the CAR OTP 2042 1783 and CAR OTP 2000-0680. And we addressed them already in our submissions for paragraph 416 and 419 of our closing brief. But if you look, Mr. President, the 3 remaining speeches given by Mr. ssona, there are 3 points which merit attention. First, as we state in our brief, these speeches advocate for an end to violence and focus on inclusivity and peace. That's paragraph 419 of our brief, closing brief. Given the clear calls for peace, it's impossible to reach the conclusion that these speeches could have contributed to the organizational policy to target Muslim civilians. It's really astonishing, Mr. President, to hear the prosecution say yesterday, English transcript, page 19, line 22-24, that Mr. ssona had a choice to involve himself in the hate speeches of François Bozizé. Where is the evidence? The prosecution has not presented a shred of evidence that Mr. ssona was involved in any of those hate speeches. Secondly, the prosecution does not even attempt to show this court how these speeches would have impacted the 5 December attacks and their aftermath. Third, the prosecution reference to Mr. ssona's contributions to crimes beyond those charged should be completely disregarded by this chamber. Not only do they not even try to show how these speeches would have contributed, but they also ignore the vast jurisprudence of this court. Because we all know for this exercise to be successful, you need a so-called strict test. What is the strict test? The strict test is that there must be a sufficient link between the uncharged conduct and the crimes for which the individual is convicted. Nataganda sentencing judgment, paragraph 129, where you find the required strict test. Moreover, in this case, Mr. President, the chamber must be mindful that it is not permitted to link Mr. ssona's conduct to any of the crimes for which the pre-trial chamber 2 declined to confirm the charges. Now, my last point regarding the alleged contributions. The prosecution alleges that Mr. Gassona strengthened the anti-Balaka capacity to commit the charged crimes, paragraph 21. Also here, such a sweeping generalized statement is not even sufficient to establish criminal liability, let alone his alleged degree of participation under Rule 145. In the written reasons for the acquittal of Mr. Bakbo and Blekoude, Trial Chamber 1 found that the same argument which was launched there by the prosecution, namely that Blekoude strengthened the capacity of the so-called pro-Bakbo forces, was too generic and did not show how the contributions allegedly attributed to Mr. Blekoude were linked to the specific crimes. And Judge Henderson's leading opinion in this case, Mr. President, paragraphs 2019-2020, are extremely illustrative for this point. And they were not overturned in appeal by the appeals chamber. The same arguments are launched here against Mr. Gassona. I would say, in line with Judge Henderson, too generic, and they do not show whatsoever how these alleged contributions are linked to any crime. Now, lastly, before Ms. Cipradoso takes over, briefly, the alleged degree of intent under Rule 145. It's again a big surprise, and maybe it's not a surprise at all, that the prosecution and victims representatives are silent, totally silent, both in written and oral submissions as to the higher subjective element needed for Mr. Gassonas to incur criminal liability. Mr. Prue addressed this point in extents in their submissions, the higher subjective element needed. Closing brief, paragraph 566 and 568. The prosecution has been unable to produce a single piece of evidence where Mr. Gassona expressed anti-Muslim animus, as we already stated in paragraph 17 of our written sentencing submissions. Why? It's simply, Mr. President, he has never harbored any hate towards his fellow Muslim countrymen. The high level of intent was clear, says the prosecution, given the leadership and representation of the anti-Balaka group on part of Mr. Gassona. That's simply the argument without any motivation or substantiation. However, the abundance of evidence demonstrates how Mr. Gassona represented the anti-Balaka with only one objective in mind, to achieve peace and stability in his country, to which topic I will return after Mr. Pedroso's presentation. Thank you.
Thank you, Ms. Pedroso.
Your Honors, it is truly a privilege to appear before you today on behalf of Mr. Ngai. So my first topic relates to the gravity assessment. And I wish to recall the 3 guiding principles which Your Honors must follow when assessing gravity in the event of a conviction. First, we know from the court's legal framework that there must be a sufficient proximate link between the alleged harm resulting from a crime, on the one hand, and the actual crimes for which Mr. Ngai is charged on the other. In other words, Mr. Ngai cannot be sentenced for harm to victims for which there is an insufficient link. Second, Mr. Ngai cannot be punished twice for the same conduct, regardless of how that conduct is defined in a potential judgment. We know that legally speaking, there are countless overlaps between the crimes as charged. But in issuing a joint sentence, ignoring such overlaps is strictly prohibited. And that is because double counting leads to a disproportionate sentence. And third, any factor which may aggravate a potential sentence must be proven beyond reasonable doubt. This is an extremely high evidentiary standard. And it is a cornerstone not only of sentencing, but of these entire judicial proceedings. This standard acts as a safeguard against arbitrary and unjustified deprivations of liberty. And after all, today's discussion does revolve around whether Mr. Ngai, and for how long, may potentially be further deprived of his right to liberty should he be convicted. I will now briefly address some of the overlaps in charges in this case. Mr. Ngai was charged with 31 counts, and this number seems impressive. But when we look more closely at the charges as confirmed, there's a lot of repetition and there's a lot of overlap. And given the limited time, I will limit myself to just a few observations. First, this case is unusual in that Mr. Ngaisona's alleged responsibility for all 31 counts is based on the exact same alleged underlying conduct. It bears reminding that the pretrial chamber held that for each of the charged locations, it was by virtue of the exact same set of contributions that Mr. Ngai could be held for the crimes. And you will recall that the pretrial chamber used the abstract concept of the same course of action in order to tie Mr. Ngai to the crimes allegedly committed by the Antibalaka in the 4 locations. Second, we see that many of the charged crimes do not have distinct factual basis. We are aware that the legal elements may differ between crimes, and that is relevant for a trial judgment. But for sentencing, Your Honors, and it's important to restate, is Mr. Ngaisona's actual conduct and the extent of harm to victims, insofar as that harm can be concretely linked to the crimes as charged. The CLRV suggested that the chamber should consider the separate and distinct harms for victims of crimes that are charged under both war crimes and crimes against humanity. We recall the trial chamber's recent finding in the case of Mr. Alassane, which recently reaffirmed that in issuing a joint sentence, the specific type of overlap must be taken into account to prevent an accused person of being punished beyond his actual culpability. And by the way, the LRV's reliance on the Ongwen trial judgment here is inappropriate. The discussion here does not concern whether Mr. Ngai can be convicted for both war crimes and crimes against humanity concurrently, but rather how Mr. Ngai could be potentially sentenced for such overlapping crimes. To give you another example of overlap, for the counts of directing an attack against the civilian population, the LRV asked the chamber to consider the harm caused to victims, and in particular, the multiple deaths resulting from the attacks on Bangui and Bosangoa on 5 December. I pause here just because I see we have issues with our PowerPoint presentation that is not displaying on the screen.
It's not a problem.
Okay.
Now we have it. It's okay.
Okay, thank you. In the confirmation decisions, however, those 2 counts are based entirely on other counts charged. These deaths and this harm, the LRV is asking the chamber to consider under counts 1 and 30, will already have been considered by the chamber in its assessment of the underlying counts, including murder. The same can be said about the crime of persecution, where the underlying basis for the 4 persecution counts are in fact all of the other counts charged against Mr. Ngai. According to the jurisprudence, to avoid double counting, only the single additional harm element of discrimination, which is found in persecution and not in the other crimes, may be considered. This is also the case for the overlapping counts of displacement and forcible transfer and deportation. The underlying acts, which allegedly led to the transfer of the population, are the exact same for both counts. So to conclude on this point, the issuance of a potential sentence must be limited to and appropriately reflect the single fact pattern underlying Mr. Ngaisona's alleged culpable conduct. And with respect to the alleged harm, which I will now address, the Chamber must be alert to the significant overlaps between the counts. The prosecution and the LRV attempt to attribute an extremely broad range of harms to Mr. Ngaisona that fall outside of the scope of the confirmation of charges decision. In other words, they overextend the alleged harm. For example, the LRV argued that Mr. Ngaisona should be punished for the harm done to the entire Muslim community. The OTP went even further at paragraph 17 of their brief by suggesting that Mr. Ngaisona's sentence should reflect the alleged harm extending beyond the Muslim community and to the Central African Republic as a whole. Now, this runs contrary to the court's well-established jurisprudence relating to the requirement of a sufficient proximate link between the aggravating harm and the actual crimes that I mentioned earlier. It also goes against the requirement that any factor that may aggravate a potential sentence has to be proven beyond reasonable doubt. And the trial chamber stated the standard very clearly in the Taganda case. I will now address some of the specific harm allegations raised and give you some examples of this overextension of the harm that I'm talking about. The LRV and OTP arguments concerning the long-term impact of displacement beyond the initial transfer aim to impute harms that are not connected to Mr. Ngaisona's conduct in 2013. The LRV argues that the majority of victims have not been able to return to their places of origin to this day. Yet, when we scrutinize the evidence cited by the LRV, we see that in some instances, the reasons cited for not returning are either not directly linked to the charges, or the link to the charges is insufficiently clear. For example, some of the cited victims refer to a lack of contemporaneous peace and security as a basis for not returning. And as raised by counsel for Mr. Yekatom today, there must be a cutoff point. We also note that the alleged harm to unidentified individuals in camps outside of Central African Republic, particularly where the origin of the person and their connection to the charges is not specified, cannot be considered in the harm assessment against Mr. Ngaisona. We know that the pretrial chamber declined to confirm charges in relation to several prefectures in Mr. Ngaisona's case. So such evidence is outside of the facts and circumstances of the trial and therefore of sentencing. And we trust that the chamber will be alert to these nuances. We also ask the chamber to scrutinize the evidence relied upon by the LRV with respect to gravity and harm. For instance, with respect to displacement, the LRV relies on the report of the Rule 68 to-be witness P925, which remains untested by the parties and which has limited probative value in proving the specific harm and link to the charges beyond a reasonable doubt. And the same scrutiny is called for with respect to the LRV's reliance on victim participation forms, which are not in evidence in this case and which have little to no probative value. With respect to the alleged destruction of the Boeing Mosque and the Central Mosque of Bosangoa, in their submissions, the LRV, again here, attempts to attribute the destruction of hundreds of mosques to Mr. Ngai, including in towns that are not even part of the charges here. And I'm referring to paragraph 38 of their brief. Your Honors, taking these uncharged acts into account would punish Mr. Ngai, but beyond his alleged culpability, and result in a disproportionate sentence. Even for the 2 mosques that are part of the charges, we submit that the specific impact on victims for those destructions is unclear. The LRV also invokes the persecutory motive behind the destruction of the mosques as an aggravating factor. But this case is distinguishable from the case of Mr. Al-Mahdi cited by the LRV. In that case, the trial chamber held there was a discriminatory motive for the destruction of the sites in Timbuktu. But the facts were very different. The chamber had found that Ansar Din and Akim took measures to impose their religious edicts on the population. It also held that the leaders of Ansar Din destroyed the sites to stop practices which were prohibited by their version of Islam. There's no such evidence here that the Anti-Balaka held such motives to impose their religion or eradicate the Muslim faith, whether in the destruction of those 2 mosques or in any other crime. And we refer your honors to our closing brief at paragraphs 247 to 262, where we have addressed the absence of anti-Muslim animus by the Anti-Balaka. And here I'd like to recall the trial chamber's reasoning in the Taganda case in addressing the inter- or transgenerational harm, which has been raised by the LRV and the OTP in this case. In that case, the chamber declined to consider this particularly broad harm because of the, I quote, complex questions of causation involved in determining this type of harm to a beyond reasonable doubt standard, and the very general nature in which this type of harm has been referred to by the LRVs in that case. Similarly here, the types of harm evoked by the LRV relating to the Muslim community, for instance, the loss of religion, is equally complex, and it has not been established beyond a reasonable doubt. Even witness P475, cited by the LRV, admitted that those who had abandoned their religion were the ones who already had little faith, showing the complexity of causation. And for the alleged harm related to the charge of rape, Your Honors, Mr. Knops has addressed it, and suffice it to say that the alleged second rape bears no link whatsoever with the charges and cannot be considered in the gravity and harm assessment or as an aggravating factor. The LRV and the OTP also argued that the victims were particularly vulnerable in this case, and that this should be considered as an aggravating factor pursuant to Rule 145 2B. The LRV argues that children and elderly were the most affected, and that women were more affected than men. Where do these figures come from? The LRV relies on a chart produced by the registry, providing a general overview of the age and the sex of victims in 3 locations, as you can see. If we look closely, we see that these figures are not reflected. The chart shows that, in fact, the age group most affected by the crimes is not children or elderly, but rather persons in the age group 40 to 54. And for all 3 locations, we see that children and elderly are clearly in the minority, and there are no statistics for children under 10. And with respect to the sex of the victims, again, the LRV's claim does not correspond to the chart they rely on. We see for the 5 December attack in Bangui, women between 25 and 69 are more affected than men. But in the age group of persons between 10 and 24, victims are equally divided between men and women. And for persons over 70, there are more men than women. And in Bosa and Goa, there are more men than women victims overall. The bottom line is that this chart is vague. There are no specific numbers. We do not have access to the underlying data, which would allow us to verify these numbers. There is no breakdown showing how the victims relate to the specific charges. We also note that the numbers put forward by the LRV and the OTP with respect to the aggravating factor of the high number of victims in this case are also vague. The numbers of victims for many of the crimes are unknown. Yesterday, the OTP spoke of thousands and thousands who were directly impacted. And as held by the child chamber in the Taganda case, the chamber cannot consider mere estimates put forward by the OTP and the LRV. So to conclude on this, the particular vulnerability or defenselessness of victims in this case has not been established as aggravating factors. Contrary to the LRV allegation, there is absolutely no evidence that Mr. Ngai would have abused power or his official capacity within the meaning of Rule 145(2)(b). The LRV was unable to formulate concretely the position held by Mr. Ngai and concretely how he would have abused his power or official capacity. They merely refer to Mr. Ngai brief ministerial position prior to the Seleka coup when he allegedly mobilized the, I quote, youth. We know from the court's case law that simply being in a position of authority while committing alleged crimes is insufficient to show an abuse of power or official capacity. So we submit to you that Mr. Ngai never abused any position. And frankly, it is shocking to read and to hear the LRV and the prosecution continue to maintain that Mr. Ngai declined to use his influence to prevent further crimes, given the overwhelming evidence in this case showing that Mr. Ngai used his position to prevent crimes, to restore peace, to promote reconciliation. And Mr. Knops will delve into this topic in a bit. The LRV and OTP's arguments as to the discriminatory intent behind all the charged crimes as an aggravating factor must also fail. We have addressed it in our closing submissions, how the alleged anti-Balaka, anti-Muslim animus has not been proven, and I won't repeat it here again. It suffices to say that the beyond reasonable standard with respect to this aggravating factor has not been met. And in any event, considering discriminatory intent for all of the charged crimes, which already underlie the charge of persecution, would amount to double counting. And just one last point before I move on to the next topic. The prosecution suggested yesterday that violations of the contact restrictions regime should be considered in a potential sentence. We limit ourselves to observing that in the Taganda case, the Taganda sentencing decision at paragraph 206, the Trial Chamber 6 declined to consider breaches of the detention center rules as aggravating, as they did not prima facie have a sufficient link to the crimes, and the same reasoning should apply here. Now, before turning to Mr. Ngaisona's individual circumstances and the mitigating factors in this case, I wish to briefly address the policy aims of sentencing in this court. The principle of rehabilitation weighs strongly in Mr. Ngaisona's case and should be given a prominent place in the event of a conviction. The other two aims, that is, deterrence and so-called retribution, should be given limited weight. And we know that other trial chambers have emphasized less rehabilitation as an aim for sentencing. However, I will explain how a harsh prison sentence of 20 or 30 years would not fulfill the policy objectives of this court. Your honors are not bound by how previous ICC chambers have weighed these three principles. There is no general rule on the weight to be given to each one of them. There is no hierarchy. This is because sentencing, as your honors know, is a highly individualized and highly discretionary exercise. I note the ICTY appellate case law, which established that deterrence should not be given undue prominence. The appeals chamber in the Shelibici case, for instance, held that it was an error for a trial chamber to decide that deterrence was the most important factor in sentencing. And we asked the chamber similarly to give the principle of deterrence minimal weight here. Why? The circumstances under which international crimes are committed are exceptional. A person does not wake up one day and decide to commit a crime against humanity. They occur in a context of war, of severe unrest, of regime change. Circumstances that most of us will never imagine facing in our lifetime. And this is not to excuse in any way the seriousness of the crimes. But we ask the chamber to consider the context in which these crimes were allegedly committed, and to recognize that in such contexts, a harsh prison sentence will have little to no deterrent effect. If collective deterrence were effective, we would see fewer international crimes committed worldwide, which is unfortunately not the case. And with respect to the individual deterrence of Mr. Ngaisona, we submit to you that this is moot. The alleged actions which Mr. Ngaisona is accused of arose out of exceptional circumstances where innocent Central Africans, especially the Baya and those associated with President Bozizé, were hunted down and killed. It was a very particular and very painful moment in Central African Republic. And any alleged culpable action by Mr. Ngaisona is not bound to repeat itself. In the case of a conviction, we submit that Mr. Ngaisona has in any event been sufficiently deterred with the 6 years he has spent in pretrial detention away from everything that is dear to him: his country, his family, his career, and his plans for the future. And I will come back to that. And with respect to deterrence, we submit to you that a person who is rehabilitated is less likely to reoffend. This is because rehabilitation allows individuals to take more accountability for their crimes, which benefits not only that person, but also the community and victims. And here on the screen, I'd like to recall Judge Mumba's reasoning in a separate opinion in the ICTY Deranyich case. Not only did Judge Mumba state that rehabilitation was a key consideration, but he also stated, and I quote, that using the pen as a firearm would amount to accepting the erroneous view that you can conquer hatred with hatred. And this is an indirect reference to the limited value of so-called retribution. Judge Mumba also noted that rehabilitation after turmoil may serve to reduce the incidence of political instability and conflict. And I'd like to recall that the trial chamber in the Katanga case recognized the role of sentencing in contributing to the restoration of peace and reconciliation in the communities concerned. And speaking of principles, I'd also like to briefly evoke the preamble of the statute, as the prosecution did yesterday. Mr. Ngai and his community, to which he will one day return, all form part of this unity, of this shared heritage of all peoples, which are mentioned in the preamble. It is also our submission that for international justice to be respected, it must be fair, it must be just, it must be proportional, and reconciliatory. So we fundamentally reject the LRV's suggestion that a sentence against Mr. Ngai should be, I quote, exemplaire. I will now turn briefly to what international human rights law has to say about sentencing, which is relevant, as it is the lens through which sentencing must be interpreted by this court. Your Honors, the ICC has fallen behind with respect to international human rights standards applied to sentencing. Article 21.3 mandates the Chamber to interpret the statute in light of the evolving international human rights standards. And there has been a global shift towards more progressive concepts of restorative justice, which has been evoked by the prosecution yesterday, which promotes rehabilitation, reintegration, and non-carceral sentences. This evolving human rights law cannot be ignored by the Chamber. And that means that more progressive concepts of reparative justice cannot be ignored either. Our time is limited, so I will limit myself to evoke but a few international human rights instruments. And the first are the Tokyo Rules, adopted by the UN General Assembly, which apply to all persons subject to prosecution, including Mr. Ngai. And these rules promote the use of non-custodial measures, which we submit are not incompatible with the court's statutory framework, and I will come back to this. The rules also aim to reduce the use of prison sentences in light of human rights and social justice. We also invite the Chamber to consider the more recent Doha Declaration adopted by the General Assembly in 2016, where states parties committed to intensify efforts to reduce pretrial detention and to enhance the use of non-custodial sanctions. We also invite the Chamber to consider developments in many regional and domestic jurisdictions, which are moving away from prison sentences. The European Union prison rules and EU policies consider prison sentences as a measure of last resort, and they also encourage the use of non-custodial sentences. Several domestic jurisdictions interpret the term imprisonment more broadly than prison sentences, to include, for instance, conditional sentences, and that's the case in my home jurisdiction of Canada. And it is important to note, with respect to gravity, that such interpretations of imprisonment, so these alternative interpretations, are in some cases applied to very serious crimes, including murder, sexual assault, and other forms of physical violence. And in the case of Colombia's special jurisdiction, even to crimes against humanity. And we are, of course, aware of the Bemba and Al and Ongwen judgments, but we do not consider the issue entirely settled. These judgments did not answer the question whether imprisonment under Article 77 can be interpreted to include non-prison sentences. And we submit that this term, imprisonment, may include restrictions to freedom outside of the prison context when interpreted through the lens of international human rights law and through the extremely broad discretion afforded to your honors by the statute. And such an interpretation is not incompatible with the principle of Article 23. Given imprisonment is not specifically defined in the statute and can hold different meanings. And in the case of a conviction, the defense stands ready to provide the chamber with more detailed views on the modalities of a potential sentence of imprisonment outside a prison setting, keeping in mind that Mr. Ngai ssona has a very large family and a community to support him and to supervise any potential sentence served in the community. So just to conclude on this point, we can observe a global trend towards restorative justice, one that gives proper weight to the aims of rehabilitation and reintegration, rather than an undue emphasis on retribution and deterrence, which should not be given undue weight in this particular case against Mr. Ngai ssona. And we invite you to be pioneers in international criminal law and to contribute to the development of sentencing practices at the ICC, which align with these developments in international human rights law. I'd now like to address Mr. Ngai ssona's rehabilitation prospects and his individual circumstances. Mr. Ngai ssona is 57 years old. He is a family man and a community leader. He is married with 9 children, including a 12-year-old boy, and 13 grandchildren, with whom he is very close. Mr. Ngai ssona has the support of a very large extended family who only wish to have him return to them. Mr. Ngai ssona's higher education, his work experience, including as part of the public service, and his life skills would allow him to rebuild his life and to give back meaningfully to his community. Mr. Ngai ssona is a perfect candidate for rehabilitation and reintegration in the case of a conviction. In the literature, rehabilitation is defined as a process of getting back to normal. Mr. Ngai ssona would have no issue whatsoever returning to normalcy. In fact, Mr. Ngai ssona has already well advanced in this process. Shortly after the start of the peace process, Mr. Ngai ssona distanced himself from the Anti-Balaka, founded his own political party, and issued countless messages of peace and reconciliation. After the conflict, Mr. Ngai ssona's hard work and devotion to the world of football did not go unnoticed. We addressed it in our brief. Mr. Ngai ssona has expressed before this very chamber his vision for his party, the PCUD, through which he wishes to strive for a better future for the entire Khar population. Mr. Ngai ssona continues to promote a vision of peace, tolerance, and in particular, religious tolerance and reconciliation. The case record is replete with evidence that Mr. Ngai is well known for his good character and in particular his generosity. This is the Mr. Ngai that we as a defense team have come to know over the years. The evidence brought by the prosecution and the defense is overwhelming in this respect. They show Mr. Ngai natural propensity for helping others, including strangers. The evidence also demonstrates that Mr. Ngai showed empathy towards the victims of the car crisis, and that he tried to help them without distinction. To conclude on this point, Mr. Ngaisona's speedy return to his community would not be destabilizing. To the contrary, Mr. Ngai is clearly ready to reintegrate, and he does not pose a threat to public security or safety. We recall that Mr. Ngai has no criminal record, which is a factor the Chamber must consider under Rule 145(2)(b). So we ask the Chamber to take these personal circumstances into account in weighing a potential sentence. I now turn to my last topic, the mitigating factors in this case, which we know are relevant to diminishing a potential sentence. It is worth recalling that the lesser standard of a balance of probabilities applies here. First, Mr. Ngai has cooperated with the investigations in this case. As held by the trial chamber in Katanga, for it to be considered mitigating under Rule 145, cooperation need not be substantial. In 2018, prior to Mr. Ngaisona's arrest, and the timing is relevant here, OTP investigators sought to meet with him, and they met at the Hotel Ledger in Bangui. During this meeting, Mr. Ngai was eager to speak with the OTP investigators and answer their questions. But investigators had to stop Mr. Ngai given that he did not have a lawyer present. When Mr. Ngai was later arrested in Paris, he willingly answered the questioning of the French gendarmerie. And the record of these interviews are well documented, and they were disclosed by the prosecution, although they're not formally submitted. Also, Mr. Ngai decided to make an unsworn statement. He was not obliged to do so. It was important for Mr. Ngai to speak directly to your honors, to all of us, to the wider colored population, and to the victims. Mr. Ngai spoke for 6 hours and told us his story in great detail. He went over what he experienced during the crisis that unfolded in his country. He addressed some of the allegations against him. Mr. Ngai was motivated to speak to contribute to the further search for the truth in this case. Mr. Ngai has also always shown good behavior in the courtroom and has only been cooperative. He has attended all the hearings, complied with the courtroom rules and decorum. His behavior during court proceedings and in detention have been exemplary. When your honors permitted temporary release, allowing Mr. Ngai to mourn his father together with his family, Mr. Ngai perfectly complied with all of the conditions imposed by your chamber and by the French authorities. So to conclude on this particular factor, We know that good behavior during trial is expected of an accused person. But Mr. Ngaisona's overall behavior and cooperation have exceeded mere good behavior. Mr. Ngaisona did not hesitate to answer questions, to meet with authorities, to contribute to the manifestation of the truth in this case. And we ask the Chamber to consider these factors cumulatively in mitigating a potential sentence, in combination with further factors which I will now address. The next factor is the length of Mr. Ngaisona's pretrial detention, combined with the hardship he experienced during this detention. As we know, deprivation of liberty is one of the most egregious restrictions on fundamental human rights. This is especially true when a person, such as Mr. Ngaisona, is presumed innocent. And before delving into this topic, I wish to make it very clear that the hardship experienced by Mr. Ngaisona in detention since his arrest and by his family do not take away in any way from the suffering of the victims in this case. Mr. Ngaisona has been detained in pretrial detention for 6 years. And this delay has been unduly prolonged by the COVID-19 restrictions, by the pandemic in general, when proceedings slowed down, resulting in gaps in the scheduling and postponements. There's also the issue of the joinder, which extended the proceedings. So we asked the Chamber to consider the undue delay experienced by Mr. Ngaisona waiting for a verdict in this case in a potential sentence. Another mitigating factor are the multiple violations of Mr. Ngaisona's rights in detention. According to the jurisprudence of this court, violations of the fundamental rights of a person may be taken into account in mitigating a potential sentence, if it is shown that those violations were in connection with the proceedings before it, which is the case here. These violations include, for instance, the denial of culturally appropriate food and food that is safe for consumption. To give you just one example, Mr. Ngaisona continues to regularly receive, to this day, bread that is moldy. And this despite the rights guaranteed by the regulations. We also asked the Chamber to consider how the restrictions on communication regime actually went beyond the Chamber's orders. Mr. Ngaisona's limited contact with the outside world was further restricted by the detention center's limited staff availabilities, whose presence was required for active monitoring. Another factor is Mr. Ngaisona's limited family contacts, which has greatly impacted him and his family. In the 6 years, Mr. Ngaisona has only seen his eldest son and twice, and his father once, a few months prior to his death. Mr. Ngaisona has not seen most of his children during this time. Most of Mr. Ngaisona's family members have not been able to visit him because of the geographical distance, entailing significant financial and visa-related obstacles. Moreover, Mr. Ngaisona has never met the youngest members of his family, including his 3 granddaughters born during his detention. Mr. Ngaisona has only benefited from 3 funded visits during his entire detention due to a lack of funds in the trust fund for family visits and the COVID-19 restrictions. And my counterparts from the defense team of Mr. Yekatom have raised the obstacles and hardship resulting from the pandemic, so I won't expand on this any further, as they apply to Mr. Ngaisona as well. Mr. Ngai-sona's inability to fulfill his crucial role as the grand baoba of his extended family and his community has impacted him and his family tremendously. Mr. Ngai-sona's family members suffer greatly from having lost their main provider. Mr. Ngai-sona's wife and children have been struggling since Mr. Ngai-sona's arrest. Mrs. Ngai-sona had to start working minimum wage in order to survive and provide for their family as best she can in the absence of her husband. Mr. Ngai-sona's children had to quit their studies for lack of funds. The family has fallen behind on important payments. These factors have further contributed to Mr. Ngai-sona's emotional distress due to the distance with his loved ones and to his feelings of powerlessness and isolation. And finally, during his detention, Mr. Ngai-sona has experienced profound personal loss. During this time, countless close relatives and friends of Mr. Ngai-sona have died. Just a few days ago, we had to break the news to Mr. Ngai-sona yet again of the passing of a dear friend. Recently, as you are aware, Mr. Ngai-sona lost his biological father, Mr. Raymond Ngai-sona. Mr. Ngai-sona was extremely close to his father. They lived together in Bangui. The circumstances of Mr. Raymond's death were particularly difficult for Mr. Ngai-sona. Mr. Raymond Ngai-sona was suffering from a serious but treatable condition. Your honors will recall that Mr. Ngai-sona and our defense team painstakingly succeeded in securing Mr. Raymond's travel to France in order to have a potential life-saving operation. And it was on the eve of this operation that Mr. Raymond suddenly passed away. Mr. Ngai-sona felt a profound sense of powerlessness and despair to have witnessed his father's health decline from afar. And Mr. Ngai-sona is convinced that he could have saved his father's life had he not been detained, given Mr. Raymond was under his care. So to conclude, we ask the Chamber to consider these difficult conditions experienced by Mr. Ngai-sona these past 6 years in detention, which are mostly hidden from the court. And we ask that these factors mitigate a potential sentence. I will now give the floor to Mr. Knops, who will now address Mr. Ngai-sona's genuine peace initiatives as a powerful mitigating factor. Thank you.
Thank you, Ms. Pedroso. I think, Mr. Knops, it makes sense now to have this 5-minute break. Please only 5 minutes, not more, and let us know when we can continue.
All rise, veuillez vous lever.